We will continue with our third case.
Thank you, Your Honors. May it please the Court. Jeremy Markman on behalf of the appellant, DB, and I appreciate the courtesy of reserving the 5 minutes for rebuttal.
Okay.
This was a negligent security case where DB was a mentally deficient patient at Florida Hospital inside the behavioral health unit, involuntarily committed, and a patient committed a sexual act while she was such a patient. The errors that the trial court committed during the trial and the denial of motion for summary judgment and motion in limine beforehand meant that ultimately the jury was not purview to relevant evidence of negligence that was required to be considered by the jury in determining whether or not reasonable security measures were available in that unit. In order to prove the negligent security case, notice is one of the primary ways that a plaintiff in the case can prove that. Without evidence of calls for service, evidence of documents of adverse incidents that were precluded from use and admissibility at trial, and evidence of police reports that would have been relevant to determine the extent of the danger presented to patients in the behavioral health unit at Florida Hospital, meant that the jury was not allowed to consider evidence of the potential risk of such sexual problems in the unit.
Wouldn't a police report have been hearsay under any circumstances?
No, not in these circumstances. In fact, under Foster versus Poe, folks, this court's case in the 5th DCA, 37 calls for service were not considered hearsay. In fact, what they were competent evidence of notice and foreseeability in order to show what the danger was prior to the incident. And in fact, the Serwinski case out of the 3rd DCA held that evidence of that sort, including police reports and calls for service, can be used in a 5-year time span before the incident to show directly notice and foreseeability, because without that notice of what the incidents are, how severe the incidents are, how often they happen, the jury can then not make a determination as to whether or not security measures are reasonable and how extensive the security...
I mean, evidence that the police were called because of a request for service is one thing, but the contents of a police report, how is that not always going to be hearsay?
It's not offered for the truth of the matter asserted, it's offered for notice and foreseeability. And in fact, since 1984 in Hall versus Billy Jacks, the Florida Supreme Court has said that the actual or constructive knowledge of a dangerous condition on the premises that's likely to cause harm is relevant evidence, and the relevant evidence in that case and its progeny since 1984 has been police reports and calls for service. What we have uniquely in this case...
Let me just interrupt you for a minute and talk a bit about the calls for service. You know, most of the negligent, in fact, all of the negligent security cases I've seen usually involve somebody gets mugged in the parking lot of a shopping mall, or in Billy Jacks, they get beat up in a restaurant or that sort of thing. And the cases clearly hold that the calls for service in the immediate area are relevant even if they're not identical. But this is a little bit different in the sense that this is a locked unit. And so I can appreciate how other incidents in the unit might be relevant, but it seems to me that if somebody gets mugged in the parking lot of Florida Hospital, wherever this Florida Hospital was, that's a bit different than somebody getting mugged in the parking lot of the shopping mall. I mean, doesn't that, the fact that this is a locked unit that is not accessible to the public, make it a different analysis than the typical security cases that we normally see?
The way I'll answer that is that the factual circumstances of this being a locked unit are not may be distinguishable from those other cases. So essentially what I'm telling you is yes, there's some factual a way to factually distinguish those cases, but importantly in this case, the security plan for Florida Hospital did not restrict the security in the locked unit. The security guards patrolled the entire property, and therefore all of the crime would be relevant. I'd also point out, though,
I go to the foreseeability, and isn't kind of the light crimes analysis relevant? And with that being the case, wouldn't that go to the trial court's discretion in this case as to what types of service calls or other criminal acts in the surrounding area would be admissible in this trial as to foreseeability?
Sure. Going to Judge Orfinger and tying off that, even if the court were to use the discretion and distinguish the other cases only to solely those incidents within the locked unit, the trial court does not have the discretion, and it is not a discretionary judgment call from the trial court to determine which crimes were admissible within that locked unit, and she excluded quite a number of those crimes, including a patient biting a staff member, a patient battering another staff member. What the case law on that holds is that all crimes, whether similar or not, are relevant evidence of notice and foreseeability, so the jury has the opportunity to determine whether reasonable security measures are in place. And in fact, Bellevue versus Frenchie's South Beach Cafe says a rule limiting evidence of foreseeability to prior similar incidents deprives the jury of its role in determining the question of foreseeability. And in fact, under
But that presupposes that these are criminal acts. I mean, I'm not so sure that I would say that in a locked psych unit, a patient biting a staff member is a crime. I mean, that seems to go along with the nature of the unit. I mean, maybe if they punch them out and hit them with a chair and things like that, maybe that rises to the level of a crime, but simply because they act out in a way that people in psych units sometimes act out, I'm not sure that that's a crime. Don't we have to kind of focus on things that are clearly crimes?
No, and the reason being because even under all the case law that admits prior criminal activities, the crimes don't have to be proven as crimes. It's the facts that are set forth in the prior police reports or the calls for service that are relevant evidence for the jury to consider, and then it's up to the opposing side to say these are what you're saying, essentially. These are things that happen in a psych unit, or these are things that are not crimes that we should put security measures in place in order to prevent against. But when you look at, for example, a patient battering another patient, when evidence of that is precluded and the jury is not allowed to determine that issue, it doesn't matter whether it's in a locked psych unit or not, and it doesn't matter what the specific intent of the institutionalized patient who battered the other patient is. What's important is, what did they do to provide a reasonably safe premises for the patient who got battered? Or in this case, what did they do to provide a reasonably safe location for DB who was assaulted here? The fact that a institutionalized patient may or may not have a mens rea to rise to the level of crime doesn't mean that a jury should be precluded from the evidence of the act and the potential injury or violation to the innocent patient.
Help me understand the facts of just a little bit better. You wanted to introduce evidence of calls for service for the greater campus area, is that right? Initially,
yes.
And the judge said no, the fact that there was a car break-in or a mugging in the parking lot isn't relevant to this locked unit.
Correct.
To what extent did you want to introduce evidence of other, what you'd call criminal acts inside the unit that you were precluded from discussing?
There was a great extent of those that were excluded, and those were excluded both in the calls for service for the locked unit and in police reports for things that happened inside the unit, and the Amendment 7 documents that were precluded from being used or admitted at trial. And the Amendment 7 documents were precluded completely from both use in discovery and use at trial. There were no questions allowed to be used. And those Amendment 7 documents included documents, for example, of an alleged rape that had the facts that were exactly like this one, and it's within the record in the supplemental record on appeal, that you can see the incident report that Florida Hospital created from that prior incident that reads just like this incident.
Is the plaintiff's expert able to review the incident reports in forming the opinion?
Yes.
That would be a use in discovery.
The trial court allowed the security expert to opine based upon a review of the reports. The only evidence that was allowed of those reports was the number of the reports, not what happened, and most importantly, not what Florida Hospital did in response to knowing about these prior incidents. Did they review the security? Did they add additional security? Did they put a unit clerk there in order to watch the video so people don't go, so a male patient doesn't go into a female patient and assault them? None of those questions were allowed, and that evidence wasn't allowed in the purview of the jury because the only thing the jury got from those Amendment 7 documents were the number of incidents within a 5-year period prior to this incident. And that's important because when we're looking at the constitutional amendment that allows these documents, what the appellee is arguing is that the purpose of those the purpose of the Florida citizens passing those amendments should be undercut in any type of litigation.
I don't think they're saying it should be undercut. I think they should be limited to the plain language of the constitutional amendment.
It's our position that the plain language of the constitutional amendment allows discovery of those documents, and then, of course, once they're discovered, the traditional rules of evidence should apply. And once a relevance analysis is done, based upon the case law that I previously cited, those documents become relevant. What the appellee is attempting to do is ask this court to add additional language into the constitutional amendment that actually reads language barring its use once discovered. And if we look at, for example, the Florida Supreme Court in Florida Hospital Waterman versus Buster adopted Judge Sawaya's language from this court's opinion in the Buster case, which set forth the 3 reasons why this constitutional amendment was important.
It's not really an argument, though, that the constitutional amendment bars admission. It's that the other relevant statutes and rules of discovery applicable to the case and rules of admission, rules of evidence still apply to what's been obtained through discovery.
Well, I've addressed the relevance issue on that. They are arguing that there's a statutory provision under the risk management statute that bars its admission. That's 395.0197. Important, and that's what they're saying bars admission or use. Understand, use in discovery. The appellant was not allowed to ask questions of Florida hospital employees about these prior incidents if they were discovered through the Amendment 7 documents. And what the Florida Supreme Court has said on that issue in Charles versus Southern Baptist Hospital, most recently in 2017, is they looked at that same statute, 395.0197, the risk management statute, and said that that is not a bar to discovery. And so they've abrogated that statute. Realistically, with regard to this constitutional amendment, this is a case of first impression for this court because no other court in Florida has discussed the use and admissibility of these documents, but each time that...
And that could be consistent with access. The constitutional language provides access, which is consistent with the language from the Supreme Court cases. I think your argument, at least it seems to me, is that we should also read access to mean admissibility.
No, I'm not asking you to read anything into it. All I'm asking you to say is once you can access those documents, just apply the traditional rules of evidence, and this provision under the risk management goes against what the Florida Supreme Court has said about the purpose of the amendment. So when Judge Sawaya's language from this court was adopted by the Florida Supreme Court, Judge Sawaya said in the Buster case that it allows access through policing these healthcare institutions in discovery and litigation. The purpose of the amendment was not solely so if you're picking a doctor or healthcare institution, you can see what bad things happened in the past, nor is it solely if you have a healthcare provider, you can see what bad things they're doing when you're getting the care, but it's also to use it at trial, both in discovery and at trial, in order to hold those healthcare institutions accountable. What Edwards in the Florida Supreme Court's case said that there was a sea change because we could no longer trust these institutions to police themselves. It's like the fox guarding the hen house. And
how do you get around the fact that access is defined in the constitutional amendment? Have access to any records means, and then it defines
You don't have to get around it, because once access is provided, then the traditional rules of discovery apply. And when we're talking about traditional rules of discovery, the only thing that they're relying on that is the relevance under 403 analysis. They're admitting that it's a 401 analysis relevance, meaning that these are relevant and the case law allows them to be not just used, but admissible. The only thing, the only other argument they have is the risk management privilege, which has been, when the Florida Supreme Court was confronted with that in the discovery context, they completely abrogated that portion of the risk management statute. This court does not have to, but can, abrogate the portion with regard to admissibility under the risk management statute based upon the same reasoning and the same justification that the Florida Supreme Court did in Charles and Edward in Charles.
What would the justification be for finding that language regarding admissibility in these statutes is completely inconsistent with the constitutional provision?
Because it's our position it's completely consistent with the constitutional provision, because the constitutional provision and the Florida Supreme Court has said you have an absolute right to these documents. And when you're talking about the language of the Florida Constitution, have access to records were defined as addition to any other procedure for producing such records provided under general law, making the records available for inspection and copying. Once they're available to a plaintiff in litigation, then the only rules that should apply are the traditional rules of evidence with regard to relevance under 401 and 403. So that's completely consistent with the language of the Constitution, because the Constitution provides an absolute right to access, and then once you have a right to access, then trial courts can apply the traditional rules of evidence to see whether or not it can be used and admissible. And implying...
Unless there's a statute that says it's not admissible.
Well, except that in this case, the statute and what the Florida Supreme Court has said is, because of the sea change in the Florida patient's right to know statute, our constitutional amendment, those statutes and prevention of access to those records are abrogated. So this court can also find that the provision with regard to admissibility is also abrogated.
How would we find that, though? How would we find that a provision regarding admissibility? There is a rule, I think you would agree, that statutes should be read as consistent with the Constitution if possible. There's also a rule that a constitutional amendment does not implicitly overrule a previously existing statute unless they're completely inconsistent. So how would we say that a rule regarding admissibility of documents is completely inconsistent with the right to access?
The way you can say that is because the purpose of the legislative intent and purpose of the constitutional amendment was to provide such access, and then the traditional rules of evidence apply, and the traditional rules and providing such access means that the purpose of the constitutional amendment would be completely undercut if you weren't allowed to use it or they weren't admissible.
How is that different, for example, from the accident report privilege? I mean, the accident report is certainly discoverable, but the contents of it are not admissible. I mean, how is this any different? Just because something's discoverable doesn't necessarily equate to admissibility.
Well, the way that's different is, one, we have a constitutional provision that allows an absolute right to access, and two is that the accident report privilege doesn't preclude the use in discovery or use at trial of what is revealed in an accident report. It does preclude admission, but you're still allowed to ask questions during discovery, and if those questions are inconsistent or you can use it under other provisions, then you are allowed to use those in discovery and at trial, even though you don't actually put the accident report into evidence. I only have a very limited amount of time, if I could reserve. Thank you.
May it please the court, Diana Stein on behalf of Florida Hospital. And I'll start with the police reports piece. I want to clarify the record on that. Judge Roche went through all of the reports, and she actually admitted into evidence over defense objections every police call for service that occurred inside the unit. And I do think our brief was a little unclear on that, but going through just the transcripts of the discussion starting on page 1082, she said overruled, that's all coming in. So the jury had 14 reports of calls for service that occurred inside the unit involving everything, biting someone, I think punching someone, and she said under just the case law on foreseeability, that was going to come in. So that's number one. The jury heard that. Plaintiff hasn't put into evidence what was excluded, and as Your Honor pointed out from the transcripts, it appears that it's things that were outside of the center, like community calls for service. This case was not about that. This was something that happened inside a locked unit. There was no allegation in this case about anyone entering the unit improperly. This was just about something that we admitted, the defense admitted, was foreseeable, patient-on-patient sexual encounters in a mental ward, and whether there was proper security in place to prevent it. So the police reports is a non-issue. Everything that we didn't even want to come in came in, and she only excluded the calls for service that occurred outside the locked center. As for the adverse incident reports, now 3 judges below looked at this issue and had absolutely no problem determining that the reports were discoverable but not admissible. Now to start with the language of the statute, the Supreme Court's made clear, this was the Benjamin versus Tandem case where they looked at whether the Amendment 7 applied to nursing homes and said, we're not expanding the definitions that the electorate intended. If they say it's supposed to apply to something, that's what it's applying to. So as Your Honors, I think, perhaps have acknowledged, there's nothing in that statute, I mean, in the constitutional amendment that says anything about admissibility. And so we...
Your position is that the admissibility or the inadmissibility is governed by the peer review statutes and that sort of thing?
Purely by the... Yes, Your Honor.
What does the language in those statutes, and there's 2 or 3 of them, and they all say pretty much the same thing. The language says that if information, documents, or records are otherwise available from the original source, they're not shielded from discovery in use in civil actions. So, for example, I'll make up a hypothetical. They get an adverse incident report, a Constitutional Amendment 7 report that says that patient X was sexually assaulted by patient Y, and it was witnessed by Nurse Jones. Are they able then to go out and and let's assume we agree with you that they can't admit that into evidence. But can they go to the original sources? Can they go take the deposition of Nurse Jones and say, hey, did you see patient X sexually assaulting patient Y?
I don't see any reason why not.
I mean, would you agree with me that under that language in the statute that says you can use original sources, that Nurse Jones in my hypothetical is an original source, she witnessed the incident, and so they would be free to do that if they chose to?
I believe once the information is given pursuant to the amendment that the plaintiff is not precluded from doing related discovery in order to gain information from a proper source. But just to read, and I'll just read from subsection 7 of 395.0197, it's very clear. It says adverse incident reports are subject to discovery but are not admissible as evidence in court. Very simple language, and that's all the plaintiff was trying to do here. And just to be clear, the fact that there were 24 adverse incident reports came into evidence. It was over our objection. In fact, Judge Roche took the position that the objections were waived and let it in. So this jury knew that there were 24 prior reports of sexual incidents in the psychiatric ward that occurred in this ward. So the jury knew this information. What plaintiff wanted, and now plaintiff keeps going back to these traditional rules of evidence. Well, we never even got that far because the courts all agreed that the statute applied and there was nothing in Amendment 7 to take away from that. But these reports themselves, I mean, these were incidents full of hearsay of the person in the hospital writing down psychiatric patient statements about what they said occurred to them. And it is, I mean, if it's in the record, plaintiff added it to the record. I mean, these are people who are, a lot of them delusional. Some of them have recanted, in the report itself, recanted their allegations. Some of the allegations just didn't make sense. So just under pure 9403, this had no business in the trial, even if there was no statute precluding them from coming in.
But again, let me try to understand in my mind. So we've got our Amendment 7 documents, which everybody agrees are discoverable your contention is, are not admissible. But you would agree that under the peer review statutes, that the original source of those information, if they learn that Nurse Jones witnessed an incident and they're particularly interested in that incident, for example, you don't think there's any reason under the statute why they can't go out and take Nurse Jones's deposition and then argue, well, they are obviously on notice that this was something that happens, but apparently that wasn't a dispute anyway.
Well, and I preface this by saying, and I intend to answer Your Honor's question, but this wasn't an issue here. So and I don't want to say anything wrong, it would be our position that you can't do oral discovery on Amendment 7 type information, which has not been addressed by an appellate court. In other words, you can't necessarily depose a risk manager on what the incident reports say, because that's not a record. And Amendment 7 talks about
Well, the
records.
risk manager wouldn't be an original source.
Well, but see, now we're getting into areas that just aren't at issue here, and I'm afraid of saying something that maybe isn't, all
All right, we'll save it for the next case.
that's all I'm saying, is it wasn't this case. The plaintiff, all plaintiff wanted was these reports, all 24 of them, to be shown to the jury and have the jury look at them. And
What was the logic in allowing the plaintiff's expert to testify based upon what he gleaned from those 24 reports? I mean, doesn't an expert's opinion have to be based upon facts and evidence?
they can be. And what the expert said was that our expert said I wouldn't necessarily ask for those reports. The plaintiff's expert said we try to get those reports if they're available. There was no issue in the trial as far as not allowing an expert to look at records and testify based on those. All this has to do is whether these 24 documents, records taken from adverse incident reports should have been admitted. That's it. And the jury heard of their existence. Plaintiff hammered on it in closing to the point that the judge stopped him, but I mean, it was very much known to the jury. And just to add one other pertinent fact, the hospital never disputed that sexual incidents between psychiatric patients are entirely foreseeable. The whole position is we know it happens because psychiatric patients kind of have this sexual preoccupation. That's why we have these 15-minute checks on them. So there was nothing even harmful about the jury not seeing these very, I'd say, prejudicial adverse incident reports with records of what psychiatric patients told wards and technicians and so forth. They heard it all. So I think that is very significant to that analysis. The other thing I'll say about Amendment 7, just to put it in context of this case, but there's discussion of what the purpose is. Well, we know what the purpose is because the Buster Court has talked about it. And it said that, and to be specific, the purpose of Amendment 7 is to allow patients to better determine from whom they should seek health care. In other words, it's a safety measure. Evaluate the quality and fitness of health care providers currently rendering service to them, and allow them access to information gathered through the self-policing processes during the discovery period of litigation filed by injured patients or the estates of deceased patients against their health care providers. This was not a medical negligence case. This was not a case saying that there were adverse medical decisions made. Plaintiff is trying to shoehorn these Amendment 7 documents into a negligent security case and say that somehow the security guards at the hospital perhaps should have gotten what are essentially privileged documents and analyzed them and known that sexual events happen in a psychiatric ward when in fact everyone admitted they know that. So this isn't even really something that Amendment 7 contemplated, other than the fact that DB was in fact a patient and was entitled to the records, and so she got it under the amendment. But that, again, this is pure and simple, a negligent security case, and there's no purpose in this situation to allowing it in, and frankly, the jury heard everything on an issue that wasn't even in dispute. So I would submit, and now there were numerous other issues raised. I think we've addressed them all in the brief, and I'm not going to address them because they weren't addressed by counsel unless your honors have any specific questions about any of them? Or okay, with that, I would respectfully submit this was a fair verdict. The evidentiary matters, the rulings were all correct. 3 judges below were all consistent with each other, and we would ask that the court affirm the judgment entered below. Thank you.
Thank you, Your Honors. Directly with regard to your question, this case does involve the preclusion of discovery from original sources, just like what the hypothetical was that you provided. We were not allowed to go and depose Nurse Jones, and I think in the record on appeal, it was Judge Kess's order that precluded such discovery. We weren't allowed to ask or subpoena any other witnesses in that regard to ask them about anything that arose from what we discovered in the Amendment 7 documents. I think that's found in the record on appeal. I believe it's the 1129 in the record.
Help me remember, though, is that one of the issues that we're asked to consider on appeal?
Yes, because what I've said is I've said that the use and admissibility of these Amendment 7 documents was precluded. So I wasn't allowed to ask any questions of risk managers, call any witnesses, or ask any questions in discovery of this. And then when I attempted to proffer the answers from the only one I was allowed to ask questions, but they weren't required to answer, which was the risk manager at trial, I was precluded from making the proffer, which is reversible error right there, because this court doesn't have the questions and answers that I would ask the risk manager based upon those Amendment 7 documents at trial, because the trial court precluded me from making such a proffer. And then I would also point out, if this was a juvenile ward versus an adult ward, we wouldn't be having these issues, period. The issue of consent that was argued by the appellee in this case would not have been an issue, and the undisputed facts show that she had no ability to consent. So I would ask this court to reverse and remand to direct granting of the motion for summary judgment and motion limiting on the issue of consent, and remand for a new trial.
Thank you.
Thank you.
Thank you both.